Hey, I'm going to get you up to date on the Rockland County, New York lawsuit challenging the 2024 election. I'm Lulu Friesdat. I'm the co-founder and executive director of Smart Elections, and I'm also the founder and executive director of Smart Legislation. Smart Legislation is our action arm, and that is the organization that we use to file this lawsuit in Rockland County, New York, challenging the 2024 election. I am really sorry. I know that people were waiting, but we're doing our best to get this information to you. We are working really, really hard, and it is a little bit taxing sometimes. So I hope that you can be patient with us. Thanks so much. So the latest thing that happened on August 29th, our response to the motion to dismiss was due. So to give you a little bit of background, we filed the case on December 5th. That was 30 days after the November election. That's when it was due. And then the Rockland County Board of Elections has been trying since that time to have the case dismissed. They've asked repeatedly, and so far the judge has denied that. But at this point, they filed a formal motion to dismiss, and then we filed a formal response to their motion to dismiss, and then they're going to get another chance to respond to that. It's called a reply. So just to give you kind of a sense of what the timeline is coming up, we put some information up on the website. So if you go to the website, that is smartelections.us, and I'm going to just kind of walk you through where to find different pieces of information. So this is our homepage, and what you will see there is our tremendous gratitude for the funding that people have put toward this lawsuit and toward the rest of our work. We've raised $169,000 so far since we started on this journey. And we just want to extend our deep, deep gratitude to everybody who's been donating. We know how much you care and we know how much it means. So we're really grateful. We are continuing to fundraise because we are still pursuing this lawsuit, and we don't know how long that road is going to be. Could be lengthy, and therefore we really do need to keep fundraising in order to make sure we can pursue it all the way to the end. For example, if we have to file an appeal, we're going to need more funds. And we are also pursuing other lawsuits. We have a second lawsuit that has already been filed, and we're looking at some other lawsuits. So please do keep funding. If you've donated, thank you so much. And if you haven't donated, please do. You just go to the website, smartelections.us. And then when you're there, you just click on donate, and it literally will take you 30 seconds. And it is tax deductible. We are a 501c3. So that's what you can find when you're on the home page. Now you're going to go to lawsuits, and under lawsuits, you're going to see what the latest timeline is. So as I said, there was a formal motion to dismiss on August 29th. We filed our response. They're going to have 2 weeks for another reply, and then that starts the clock ticking for the 60 days that the judge has to rule on the motion to dismiss. She's not ruling on the recount yet. Right now, she's ruling on the motion to dismiss. So her ruling is going to be due on November 11th. That's the next date to watch. We reset the clock. November 11th is the date by which the judge is supposed to rule on the motion to dismiss. If she denies the motion to dismiss, we're moving forward. And hopefully then we're going to get that full hand recount for the Senate and presidential election in Rockland County for the 2024 election. If she accepts the motion to dismiss, then at that point the case would be dismissed, but we do have that option to file an appeal. We did a really, really strong defense, and our attorney, very talented attorney named Aaron Foldenauer, has made sure that every step of the way we are protecting our right to file an appeal. So let's just talk a little bit about the motion to dismiss and what our response is. Our basic assessment of their motion was that it was very weak. They had missed deadlines, they had misstatements of fact, they misquoted the New York election law, and they also were bizarrely ignoring standard legal protocols. So we called them out on all of those fronts, and I'll talk you through some of what is in our response. So the first thing I want to do, I want to show you where these documents are so you can find them for yourself. So like I said, you're going to go to our website, and you're going to go to lawsuits, and under lawsuits, you will find that it says, please check the Smart Elections YouTube channel for details. That's probably what you're watching right now, either on YouTube or TikTok or some social media channel. And then it says the document is below. So then you click on that, and that takes you to the response to motion to dismiss. This is the document that I'm going to be discussing with you. So that's how you can find it for yourself, and you can read the whole thing. So I'm going to go through our legal document and walk you through some of the arguments that we made. I can't take you through the whole document. It's actually a pretty long document, and it has some fairly complex legal arguments in it. But the one section that I really want to walk you through is this section where the Rockland County Board of Elections absolutely misrepresents the facts. And they misstate the facts about the most shocking thing, which is the actual number of affidavits and the number of votes that they miscounted. So of all the things that you would want them to be accurate on, you would hope that they would at least be accurate on the number of votes that were counted. But that is specifically what they misrepresent. And it seems quite deliberate that they misstate the facts. And so we called them out in our response to the motion to dismiss. So the first thing to look at is their actual motion to dismiss, document number 78. They're describing the affidavits that Diane Sayre got. Diane Sayre was a candidate for Senate in the 2024 election. They were sworn affidavits of voters saying that they voted for her. And they say she then obtained signed affidavits from a small group of voters in 2 districts, discovering that the results did not exactly reflect the vote totals from the Rockland County Board of Elections. In Election District 62, 3 voters signed affidavits claiming they voted for Sayre, and the Rockland Board of Elections only recorded 2. Now that is just factually inaccurate. If you go to the actual exhibit that we put forward, you will see they said that there were 3 affidavits, but actually there were 4 affidavits. So you can see the aqua here, the light aqua, those are the number of affidavits. There were 3 that said they voted for Sayre in early voting and 1 that voted for her on election day. That's 4. Plus, the board acknowledged that she had a vote in the absentee ballots. And so actually she has a minimum of 5 votes here in District 62, and they only counted 3. They counted 3 out of 5. That's 40% of her votes that they didn't count. But they don't acknowledge that in their motion to dismiss. They try to play it off and say that they only missed 1 vote. They said that there were 3 affidavits and they recorded 2. So they actually misstate the facts there. And then they go on to the next sentence and they say, similarly, in District 29. Now keep in mind that it's not District 29. Diane Sayre had affidavits in District 39. So they did not even bother to correctly identify the district where they had the affidavits. I don't really see how you could get much more sloppy than that. They said, similarly, in District 29, they have the wrong district, and then they say 6 voters signed affidavits, which is not true. It was more than 6. So if you go and you look at the actual documents, there were 7 voters that signed affidavits for election day and 1 voter that signed an affidavit for early voting. So she actually had 8 affidavits. And then in addition to that, there was another vote in early voting that the board acknowledged that she had. The board acknowledged that she had 2 votes for early. So there's a minimum of 9 votes for her in District 39. And the board only counted 5. So there's 44% of her votes that didn't get counted in District 39, but they play that off and they pretend like they only miscounted 1 vote. So they say 6 voters signed affidavits stating they voted for Sayre, and there were only 5 votes recorded by the Rockland County Board of Elections. That is just not true. They're trying to say that they only miscounted 1 vote, when in fact they miscounted 4 votes, which was 44% of her total. And then they say that the only tangible evidence of irregularities were the 2 vote differences between the affidavits and the Rockland County Board of Election records spread across 2 districts. They're basically completely misstating the facts and trying to play it off like there was only 1 vote difference in each of those 2 districts. And they also say the only tangible evidence of irregularities, meaning that they totally disregard the other issue that was brought up in our initial complaint. Our initial petition states that there is a severe drop-off issue in the Rockland County elections, and they don't address that at all. They say the only tangible evidence of irregularities are these 2 vote differences, and they don't even deal with the drop-off, which is a huge weakness in their motion to dismiss. They're misstating the evidence, and they're not even acknowledging another huge part of the evidence. And so in our response, we really go into this. And you can see that this is our response now. Respondents' failure to accurately interpret the irregularities that are documented in the petition and accompanying affidavits further calls into question respondents' ability to accurately count votes, including in the 2024 presidential and U.S. Senate contests, which are the subject of this action. And then we say extrapolating these irregularities across the entirety of Rockland County would result in significant and concerning discrepancies in the vote tallies, which will be further explored during discovery as this action proceeds. Because if you think about that, if 40% and 44% of Diane Sayre's votes are missing, if you extrapolate that across the district, those are huge, huge irregularities. And then we go on to say that respondents' errors regarding the number of missing votes seem designated to deliberately minimize the errors that respondent has made in counting the votes. This distortion of the facts, which was either deliberate or careless, makes the need for a recount more urgent, given that it calls into question respondents' approach to this action and whether they strive for accuracy in both this action and in recording and counting votes. And then we also point out, given that the votes for Sayre were incorrectly recorded, there is every likelihood that other ballots in other races, including the U.S. Senate and presidential races in Rockland County, also suffered a similar fate. After all, if voting machines are counting the Sayre votes incorrectly, they're also likely counting other votes incorrectly as well. A hand count, if ultimately granted in this action, would be an important step to ensure that voters' legal rights to have their votes counted accurately are protected. And in any event, respondent is utterly incorrect in asserting there were only 2 vote differences. So those are some of the main arguments that we make. And the other argument that I wanted to show you is just that there definitely is a very clear path to a recount in the New York State election law. And this is in section 16-113-2. And this is something that the Board of Elections absolutely ignores, proceedings with respect to voter verifiable records. The Supreme Court, by a justice within the judicial district, so that's us, we are in the Supreme Court right now, and it is justice within the judicial district. So that totally applies, may direct a manual audit of the voter verifiable audit records applicable to any candidate running for office within such judicial district or county where, and number 2 applies to us, where evidence presented to the court otherwise indicates that there is a likelihood of a material discrepancy between such manual audit tally and such voting machine or system tally. So this is a part of the New York election law. It perfectly describes the case that we have brought before the court, and therefore in our response to the motion to dismiss, we point out a number of places within our document that this section 16-113-2 is perfectly applicable to this case, and that there is a very clear path to a recount here. And one of the things that we have to address is that the Board of Elections is saying that smart legislation does not have standing to bring this case. And they're saying that because a number of the plaintiffs left the case. Diane Sayre, who was a candidate for Senate in the 2024 election, and 2 voters who voted for her were originally plaintiffs along with smart legislation, but they did leave the case. But one of the things that we're pointing out in our response is that we believe Diane Sayre was intimidated into leaving the case, and therefore we don't think that the standing argument should hold because there was foul play, in our opinion, in regard to her leaving. So I want to just show you why we think that so strongly. When Diane first started this case, she was very, very enthusiastic and assertive, and she was not intimidated in the least. I'm going to play you a video that she made in December of 2024, and you're going to see she was very eager to pursue the case. So this is not Diane Sayre. This is a woman named Cynthia Pooler who's interviewing Diane Sayre. And I just put together a few clips so you can really see just how assertive Diane was.
Welcome to Cynthia's Political Playbook. I'm Cynthia Pooler. My guest today is my friend Diane Sayre. And Diane ran for the United States Senate in New York in 2022 for Senate against Schumer, and then 2024 against Kirsten Gillibrand. So, Diane, wasn't it fun?
It was fun. So I decided to run against Schumer, actually, particularly because of the comments he made when General Flynn and then later Donald Trump said he wanted to audit the intelligence agencies. And that I thought was a very good idea, long overdue. And Schumer was on with Rachel Maddow, who asked him about this. And he said, oh, that's a dumb idea. The intelligence agencies have 6 ways from Sunday to get back at you. And when he said that, it indicated to me who owns him. And I think that's a big problem. And someone with my background, as I said, having worked with LaRouche, who had 400 FBI agents show up at his house and spent 5 years in federal prison, I'm not going to be intimidated by that. And I want to take these agencies on. How can they deny doing a hand count of the paper ballots?
Has the Board of Elections been in contact with you? They must be furious with you.
Probably. We just served notice to them yesterday. Formal.
Okay.
So they probably are. They probably are. And they should be scared. They're breaking the law. And I would just like to draw the implications of this, because people may say, well, so what? You lost. Who cares if you got 0.5% of the vote or 10% of the vote? But my point is that we have a runaway Congress. We have senators and congressmen who think they can blow us off. They don't have to listen to our opinion.
So that was the Diane Sayre who filed the lawsuit. And when she's laughing there, we just served the Board of Elections. That was in December of 2024. And what I want to contrast that with is what happened when I spoke to her in March of 2025, when she decided that she had to pull out of the lawsuit. So in my latest affidavit to the court, which was filed on August 29th, along with the response to the motion to dismiss, I talk about how changed Diane Sayre was in March when she withdrew from the case. So this is the affidavit that I wrote. During or about mid-March 2025, I had multiple telephone calls with petitioner Diane Sayre, and these conversations occurred after Ms. Sayre informed me that she needed to withdraw from this action. I asked Ms. Sayre to explain to me why she wished to withdraw from this action. She stated to me that Lyndon LaRouche had been unfairly targeted. She explained that criminal charges had been manufactured against Mr. LaRouche. He was prosecuted and he went to jail for many years. Ms. Sayre stated something to the effect of, I can't take that risk. On multiple occasions during these telephone calls, she stated something to the effect of, I have to get off this case. I asked Ms. Sayre if I could contact the other 2 individual petitioners, Mark Murphy and Adam Mochio, whom she helped recruit to join this action with her, and she responded, absolutely not. During these telephone calls, Ms. Sayre was anxious, upset, and on edge. My prior experience with Ms. Sayre was that she was extremely confident and eager to pursue the case. It was a shock to me to experience her demeanor change so abruptly to someone who was afraid and panicked. Thus, I came to the conclusion that Ms. Sayre was being intimidated in some way to leave the lawsuit. So that is one of the documents that we submitted in response to this motion to dismiss. They're saying we don't have standing because Diane Sayre left the case. We're saying Diane Sayre, we believe, was intimidated to leave the case. Then the next thing has to do with deadlines. Now, they took a long time to bring up this issue of standing, and they actually didn't even bring it up on their own. And the next thing I'm going to read you is this transcript from July 11th, where the judge actually had to kind of just try to figure out what they were doing because it just wasn't clear. They had said they were going to bring up the issue of standing, but then they literally just didn't bring it up. So the judge had to kind of like pry this information out of them. And it's really odd. So this is the judge on July 11th, and she said, I had a question because I know Ms. Fiden, and that's the Rockland County Board of Elections attorney, when we were here on May 22nd, you pointed out that the only surviving petitioner in the case is now Smart Legislation, and that the other petitioners had withdrawn from the action. So this was already May 22nd. They had noted this, but they hadn't done anything about it. And then the judge continues, and so you had indicated at that time that you thought that there might be jurisdictional defects now with Smart Legislation being the sole surviving petitioner in this case. So then the judge says, and I didn't see any reference to that in the motion. So I didn't know if you guys were choosing just to go a different direction with your arguments. Like they didn't actually argue what they said they were going to argue. This is what the judge is saying to them. And then their attorney says, oh, no. We did address that in our memo of law. And also yesterday morning, I hope the court was able to see it, the State Board of Elections submitted an affirmation with exhibits, basically, briefing that point, which is that a proceeding. And then the judge literally interrupts them and says, I'm just saying your motion on its face does not request that relief. She's literally just pointing out that they're not doing their job. They didn't even make the argument. And the judge says, so the court can't consider that relief unless you're specifically requesting it in your motion papers. And then the attorney says, well, Judge, our motion papers are brought pursuant to CPLR 3211. She cites the section of the law, and the court says, right. And then the attorney cites some more sections of the law, and the judge says, no, I'm aware. We took a look at all those sections. I mean, I'm just trying to, where in the motion papers do you make the reference, the statutory reference to any jurisdictional or standing argument? I didn't see that. I just didn't. This is the judge saying, I didn't see that. I was surprised because when I read the papers, I was expecting to see that somewhere given what you raised on the record. And then this is their attorney just kind of like fumbling. And she goes, yeah, no. I understand the question. Our motion to dismiss, she says it right here. Our affirmative defenses did not include standing. She literally admits it, that they didn't make the argument. And then she says that was, things have changed since the individual petitioners dropped out. And the judge says, right. And then their attorney says, so now there's the standing argument in addition to all of our other arguments. And that was also raised, like I said, in the brief, in the affirmation that was submitted yesterday by the State Board of Elections, because the Rockland County Board of Elections had the State Board of Elections file a document for them. And then the judge says, so which CPLR section that you're seeking dismissal under relates to the standing or jurisdictional issue? Because I wasn't able quite to figure it out. Like the judge is literally telling them, I have no idea what you're doing. So they cite another section. And the judge says, no, I understand that you cite the sections, Ms. Fiden. I'm wondering where substantively in your papers you make an argument that Smart Legislation is not an appropriate party to bring this litigation because I didn't see that there. She's literally just telling them, you don't have it. And then their attorney says, I understand, and I will gladly do that, at your honor's request. And the judge said, well, I'm not requesting. The judge is literally just going, no, it's up to you. I'm not telling you what to do. She says, I'm simply pointing out that you had identified back in May that was going to be the basis of your motion. So when I got the motion and I was reading through it, I didn't see that basis articulated or spelled out. So I had a question about that. So then finally the judge says, are you planning on amending your papers then? And their attorney says, yes. Okay, so then we go through the whole schedule that gets reset because they have to re-amend their papers. So I went through all of that just to show you that one of the main defects of their case is that they just waited way too long to bring up this issue of standing. And our attorney just really honestly went to town on them about this. So what he said here basically is that if you're going to bring up the issue of standing, you have to bring it up fast. And that is what the case law says. So he says here, this is our attorney pushing back against their attempt to dismiss our case on the basis of standing. And our attorney says the Court of Appeals and the intermediate appellate courts have squarely held that an argument that a plaintiff lacks standing, if not asserted in the defendant's answer or in a pre-answer motion, which is like right up front, to dismiss the complaint is waived pursuant to CPLR 3211, which is the statute. So then he cites a case here. Indeed, as the Second Department concluded, since the defendant did not raise the standing issue in his answer or in a pre-answer motion to dismiss, the plaintiff correctly argued that the defendant did in fact waive any defense based on a lack of standing. And so that was in this case, Mastropolo, that our attorney cited. And then he points out, not until July 18th, 2025, more than 7 months after this action was commenced, did the board file a proposed second amended answer to its amended motion to dismiss. So basically what he's saying here is that they just blew it. He says this answer is too little, too late. He basically goes on to say that this is their third motion to dismiss. Now, in view of its admitted failure to include these defenses in its prior 2 answers, they did 2 motions to dismiss already. The Board of Elections asked the court to approve a second amended answer. That's their third shot as part of its amended motion to dismiss. The court should deny the board's request to restart this action and deny the board's attempt to obtain court's imprimatur on its third answer in this action. So basically what we're saying there is they blew it. First off, we don't believe that the standing has any validity because we believe that the other plaintiff was basically intimidated. And then in addition to that, if they were going to bring up standing, they should have brought it up much, much earlier. And that's the same with some of their other arguments. They had another argument about our petition. They didn't like the way we verified our petition, but they didn't bring it up for 4 months. And again, they really missed the boat on that. So one of the concepts that we're bringing up over and over again in our response to the motion to dismiss is that on many, many of their arguments, they are really late, and there is no reason for the court to accept their arguments at this time. I want to walk you through a couple other concepts. One is that we're adding in 3 new plaintiffs to the case, and the way that we're doing that is, again, to make sure that the judge understands that smart legislation is a legitimate plaintiff. And so what we've done is we've shown that there are members of the Rockland County community, voters who live in Rockland County who are members of smart legislation, and they consider themselves a plaintiff to the case because of their membership in smart legislation and because they've been following the case and attending the hearings. So that's what we've done in this section. We've added these plaintiffs to the case by virtue of their being members of smart legislation. So again, these are not all of the arguments that we made. We worked on this document for weeks and weeks, and it's a little bit dense legally, but I hope that you have a sense now. We've done our best to bring a very, very strong case protecting the request for the full hand recount of the Senate and presidential election in Rockland County, New York. And I hope you feel that we've done a good job. If you've been contributing, then you can see this is where your money's going, to all of these very long hours that our attorney and the rest of our team has been putting in. So thank you so much for all your support. Again, we welcome donations, and we thank you from the bottom of our hearts for caring about this and helping us fight this fight. So we'll be posting more information as soon as we have more information available. Thanks.